All right, welcome everybody. My name is Kyle Magatelli. I am the webinar and social media coordinator for Student Doctor Network. And today we are lucky to have Greg Kerr, residency law attorney, joining us to answer questions about what you need to know as a resident. Greg, thank you for taking the time to join us.
Glad to be here. Thanks, Kyle.
Cool. So before we hop into things, I'd like to tell everybody a little bit about Student Doctor Network. So SDN, quick resources overview. We have a lot of free resources. I could talk to them blue in the face. The best thing you can do is go on to studentdoctor.net, start poking around. We're best known for our forums, but we have a bevy of resources in other areas as well. But our forums, we've got communities for just about every darn professional level health field. So check all that out. You guys can read. I don't need to tell you. Now, if you're a physician or resident, we have our physician and resident communities where you can get your questions answered about general residency issues. We have a specialized forum for ERAS, SOAP, and NRMP match-related questions. And also, you can find opportunities in our internship, residency, and fellowship positions forum. And you can find us on everything on social media. Hop on there, follow us on Twitter, Instagram, LinkedIn. Check out our YouTube. We have a lot of videos, prior webinars with attendings. Just, again, I could talk a whole lot. It's a lot better just to hop on there and go check it out and not have to listen to me. So enough of me going on about that. Greg, can you please tell us a little bit about yourself and what you do?
Sure. Thanks, Kyle. So my name is Greg Kerr. I'm an attorney at the law firm of Brown, Goldstein, and Levy in Baltimore. And probably for the past, I'd say 14 years, a very substantial part of my practice has been representing residents and fellows all across the country on all manner of graduate medical education issues. And so pleased to share a little bit of that experience with you all and answer some questions you might have.
Awesome. So let's get to those questions. First one, what are some off-limits questions during residency interviews?
Sure. So assuming that we're talking about interviews through, the NRMP's, governed process, it's probably no surprise to many of you that the NRMP basically, governs and controls every aspect of that. And they have very particular ideas about that. And in the match participation agreements that you all sign, as well as the programs that participate in the match, there are very specific rules about that. And there's also federal and state law aspects to it as well. So I'll cover the NRMP part first. Starting with the interviewing process itself, in November 2021, the NRMP actually put out a statement on interviewing. And a lot of this had to do with sort of adapting to COVID and everything being virtual. But I think it still applies today that they've actually advised programs that they should give applicants up to 48 hours to decide to accept an interview request at all. So that's even before you get to the interview process. And then once you're in the interview, there are some very specific rules in the match participation agreement about what can and cannot be asked. So for example, a program can't request that an applicant disclose ranking preferences, ranking intentions, or the specialty or location of other programs that they're applying to or may apply to. Programs also cannot verbally solicit verbal or written statements of an applicant making a commitment, so sort of circumventing the NRMP's matching algorithm. They certainly are not a big fan of that. They want to be in the mix. And vice versa, residents or applicants can't try to circumvent that and try to get a program to commit before the match takes place. Programs can record interviews, but they have to ask you if they want to do that. And again, all of this is mostly through the come up through the remote forums that interviews have been doing during COVID. And if they're going to record an interview, they have to let you know ahead of time, make that information available before they extend the interview, and get your written consent before they do the recording. And in some ways, that's also governed by state law because those are conversations that are reasonable. You would have a reasonable expectation of privacy in, and various states have different rules about surreptitious recording. And so that also applies to applicants. You kind of have to remember that, you know, if you wanted to sort of tape your interview and dissect it later on and try and improve on it, you do have to be mindful that in some states, like in Maryland, where I practice law and am admitted to practice, you have to have the consent of both parties. So that's something to always consider from both sides. Programs are also encouraged not to require or imply that second visits are a determining factor in placements on the rank order list. Now, after the interview process is over, the recruitment team, whether that's the program director, the program coordinator, whoever it is at the program, maybe the GME director, if it's a small program, can exchange clarifying information with applicants, but they can't solicit post-interview communication for the purposes of influencing the decision-making. So there's kind of a fine line to be drawn there. And there should always be sort of throughout the match process, timely, accurate, and complete information is essential. So you want to be on the lookout for that from you as an applicant, as well as the programs too. Now, outside of the NRMP sort of structure is, as I mentioned, state and federal law. That applies to basically all of what we call the protected statuses, all the protected classes. So whether that's age, religion, disability, race, those are off limits questions from either a state and or federal law perspective. So how old are you? Are you planning on having a family soon? That's, you know, certainly two issues I've seen come up a lot in my practice. Also, you know, do you have a disability? Something like that. There are ways that programs can ask those questions the right way. So for example, in the disability context, they could say, you know, would you be able to do the essential functions of this job with or without a reasonable accommodation? But they can't say, do you have a disability? That would be a discriminatory question right out of the box. Sexual orientation, you know, religion, marital status. Again, those are all issues that are verboten under either federal or state law. And I should just sort of add a tangential but related point is that applicants should be sure that programs give them all of the policies on eligibility criteria before the rank order list certification deadline. That should be something that you're definitely making sure you do get, either in the interview process or before that rank order list certification deadline.
Okay. So, hey guys, if you have questions for Greg, please submit them in the chat for us. Thank you. That's a lot. This is why you're the lawyer and I'm not. All right, next question. What is the process for requesting waivers and or opposing waiver requests made to the NRMP?
Yeah, so again, the NRMP is pervading our lives, mine as well, particularly in the springtime when waivers are always an issue. After the match, things change, things happen in people's lives, and it happens in the programs too. So again, the NRMP is the sole arbiter of waiver issues, whether it's you defending against one or you asking for one. And it's important to note that you really have to be very careful about the waiver process because it's not something that you get a second bite of the apple on after the waiver process is decided. There's no court challenge, there's no arbitration about it, unlike with a match violation, which we may talk about pretty soon in this presentation. But you really want to try and get everything you want to say about that issue in during the waiver solicitation process. The bad news is that happens in a very short period of time. The NRMP usually, once they get a waiver request, will ask for the other side to give basically their position on it within 2 to 3 business days. And so that's scant little time for you to kind of get your, response together if you're the one responding. And my recommendation is to always have somebody who's got some experience dealing with those to help guide you through the process. Now, there's basically 3 grounds for a waiver. There's ineligibility, there's extreme and unanticipated hardship, and then there's change in specialty. For those of you who are going to be in the position of, applying to a couple of different specialties and you're going to wait and see sort of what happens, just keep in mind that you get matched to, say, a neurology program, and that was sort of your second choice, and maybe psychiatry or some other specialty was the first. You're committed to that program regardless of whether something greener and shinier and nicer shows up afterwards. you have to get a waiver if you want to try and change specialties. That waiver's request is usually due, it's either December or January before your training would start. So you really have to be on the ball asking for that on the early side. A lot of people come to me and it's usually too late for them to do that. And we have to sort of try and fit it into one of the two other criteria. The ineligibility one is pretty straightforward. Most of the time, I'm dealing with ineligibility issues from the standpoint of a program asking for a waiver, as opposed to the resident or the fellow trying to get a waiver on that basis. The hardship, a lot of times that's based on personal life circumstances, whether it be a health issue, whether it's physical health or mental health. Family member is obviously, sort of under that umbrella as well. It doesn't have to be just you. To give you some examples, I've dealt with clients who, sort of developed, new diagnoses or conditions that they had to have treated, and sort of moving away to whatever the program they were going to go to was going to, cause a hardship for them. They needed to stay closer to their support system and their doctors. So usually those are ones that the NRMP doesn't really question too much. The ones where you sort of, want to have a good presentation, good set of facts, usually something supporting that request from somebody who's in your treatment team, to sort of lend legitimacy to it. My perspective, again, is you can't be too careful in this process, because, one thing to keep in mind too with the ineligibility-based waiver requests, if a waiver is granted on the basis of ineligibility, you can't even ask for reconsideration. Oh. There is a reconsideration process for undue hardship. You can say, hey, NRMP, you missed something, or there's this new fact, or whatever the case might be, but you don't even get that reconsideration on ineligibility ones. The NRMP's default is we're going to honor a match commitment unless you can persuade us that there's a good reason to do that. And all of this applies to the SOAP as well. So whether it's the main match or whether it's the SOAP, you're still, on the hook for that commitment unless you have a good reason. You're committed up to the first 45 days of your training period. So, one thing I really have to, impress upon everybody is you must get a waiver before applying to other programs, before interviewing with other programs, or reaching out to them. If you're committed somewhere, you got to get that waiver first, or else you're really setting yourself up for a match violation investigation, which is nobody's best friend. And by the same token, programs can't rescind offers or fire you without first getting a waiver in those 45 days. And I've unfortunately been dealing with a couple of those this waiver season. And we've been successful in pushing back on those on that basis. Programs, by the way, can't seek a waiver unless they gave you, based on ineligibility, if they haven't given you that eligibility criteria before the rank order list certification deadline, if we're talking about the main match. And if we're talking about SOAP, then they have to have given that information to you before they extend you an offer. So make sure that if they're asking for a waiver and they haven't supplied that, that is a golden argument for you at this point with the NRMP in trying to defeat that waiver request. And basically, just want to reiterate, if you get one of these, act fast. I mean, we try to respond to as many of those as we can. There may be other attorneys out there who do it as well, but it's a pretty small community. So it's best to jump on that as quickly as possible. And usually it's a pretty self-contained process. We can knock it out in the course of a day or two if we have that time.
Okay. Wow. Well, next question. This one dovetails pretty well. What recourse does someone have if the NRMP is determined they committed a match violation?
Yeah. So, the NRMP, again, they vigorously investigate and sanction violations of the match participation agreement. There's no question about that. Common violations are, you fail to provide timely, complete, and accurate information during the recruitment process. And that's oftentimes comes up, maybe you had a criminal conviction at some point. And by the way, that's another one of those interview questions that can vary from state to state. So be aware of the state laws where you're looking for a program. They may have even more protection for you in terms of disclosing any kind of conviction, especially if there's an expungement. So you really need to be aware of all of those differences. Local counsel in those jurisdictions can probably provide that advice pretty quickly at a low fee. But those are the kinds of things that people often get tripped up on, and the programs say afterwards, hey, wait a minute, they didn't tell us this. They may ask for a waiver, number one, on that basis. We didn't know what we were buying, essentially. And two, you failed to provide timely, complete, and accurate information. And so then the NRMP is breathing down your neck with a match violation. The other one that I mentioned before, applying to programs despite having a match or sub commitment, you just can't do that. So what happens if you've sort of already gone down this road, the NRMP is reaching out to you. So once the NRMP advises you of an investigation, you then have an opportunity to respond to the allegation they've identified. At that point, they'll either drop it based on what you've told them, or they'll issue what's called a preliminary report. And that summarizes the violation that they have found and the evidence for it. But that's not the end of the process, as it's a preliminary report. So then you have an opportunity to respond to the preliminary report, and then a review panel at the NRMP decides if there is in fact a violation, and then they propose a sanction if they do find a violation, and they issue a report of that. So that final report, you have an opportunity to contest that if you're the one who's the violator. And the way you do that is through arbitration. And this is not a particularly favorable setup for residents, mostly because it's a very expensive process. It's usually on the order of $5,000 to $6,000 just to initiate it. And then, unlike in court, where judges who are paid by the taxpayers to resolve disputes, you actually have to pay an hourly fee to the arbitrator to resolve this dispute. And that cost is sort of split by the parties, but it's still, you usually arbitrate. It's tough to find one for less than $500 per hour, and so the costs mount. You also get limited discovery, so sort of limited opportunity to find out what the other side has in terms of documents and things like that. And it's not always sort of the friendliest in terms of your burden of proof. If you are challenging the NRMP's finding of a violation, you have to prove by clear and convincing evidence that the decision was arbitrary or capricious. That's a lot of legal mumbo jumbo for you really got to bring it. You have to have a pretty solid case for why the NRMP is wrong. And in theory, the arbitrator is neutral, right? But you often I find that there is an uphill battle for anyone who's found to have violated the match participation agreement. And then sanctions, right? So if the violation is upheld, then you are facing potentially 1 to 3 years of being prohibited from participating in the match. You'll be labeled a match violator in the R3 system that the NRMP uses. So that's always going to be on your record. They'll tell everybody who's had any role in your education so far in life that you're a match violator. Your med school, your undergrad, the licensing boards, it's not fun. So again, my advice is if you get one of these letters informing you of an investigation, it is important to get competent legal advice as soon as you possibly can.
Well, that's intense. All right.
Yeah. Yes, it is.
Wow. Any questions you guys have, please submit them in the chat. Wow. So what I'm hearing is going into the whole match, have your ducks in a row.
Yeah, you want to, if you know that you have sort of a red flag or there's a potential catch, it's good to get out in front of it. Get some advice beforehand about how to handle it rather than waiting for it to potentially become a problem. Yeah, absolutely.
Yeah, knowing competent lawyers is just good life advice in general. All right, next question. How should residence fellows deal with remediation and the process that precedes serious discipline, i.e. non-renewal, non-promotion, dismissal?
Yeah, so there's a fairly basic formula, but it always kind of changes depending on the situation. I mean, one of my sort of pet peeves is a lot of times a big problem, a big mistake that programs make is they say, you resident are not doing well at X, Y, and Z. Get better. There's no plan, there's no guidance, there's no help. And that's really the complete antithesis of what the graduate medical education process is supposed to be. It's supposed to be, we're the, trained, experienced faculty and attendings. We're here to, take you under our wing and show you the right way. And a lot of times, unfortunately, there's no plan, there's no support. And so asking for a remediation plan, and not only that, but asking to be part of the formation of it. That is an ACGME requirement for all programs, is that if you're resident in remediation, that you have that opportunity, because you yourself will know what you need to succeed, paired with the experience of the program as well. It's super important to find and then become familiar with all of the institutional and program level policies on things like remediation, evaluation, promotion, and due process. You want to be sort of looking at the long game. You want to be thinking about where could this possibly go, as well as what are the processes for right now? How is this supposed to be handled? What are they supposed to be giving me under their own policies? And don't be afraid to ask. Make sure that you're making sort of documented attempts to ask for these things, whether it's feedback or whether it's a remediation plan, whatever it is. Do an email, something that contemporaneously captures that information, so that later on down the road, if it does morph into more severe discipline, that way you've got something that you can point to. You can say, on X date, Dr. So-and-so told me that I was doing really well at this, as opposed to it being sort of this, 8 months down the road, who remembers who said what, and it's he said, she said. That's one of the biggest things that I really advocate for my clients to do as much as possible, and it's extra work, but document contemporaneously feedback and expectations that you get. Ask for examples, ask for specifics. Don't settle for sort of vague, well, we just don't think, your medical knowledge is where it should be. Well, what aspect of medical knowledge? What aspect of patient care? Ask, again, sort of same point as with the remediation plan. Ask for learning resources and for help. If there's a particular faculty member who's good at whatever it is you're not supposed to be good at, then ask to sort of, have some kind of tutelage from them. If you need accommodations because of a disability, begin that process ASAP. You can't wait until after discipline has been imposed and say, wait a minute, I really could have used Dragon in order to do, my notes and things like that. You have to sort of start that process on the early side. And really, again, sort of begin looking for competent counsel to guide you through it. It's not sort of my most favorite thing to do, but because it's very dynamic and it's a lot of work to keep up with it. But where I can be helpful, I'm always glad to do it. Because this is not an easy process to navigate, and sometimes you need that support.
Okay, cool. Got a couple of questions that came in. First one, can you describe what you mean by red flags?
Sure. Yeah, and I think that's sort of related to, the recruitment and interviewing process. If you've got a criminal conviction, and maybe you had that expunged, maybe you didn't. Another example is if you've got, permission to use medical marijuana in the jurisdiction where you're living, or, we're completing medical school or whatever. Know what you're walking into with the state that you're applying to, what their policies are at that institution you're applying to, and what they're going to expect in terms of your, testing positive for something that is otherwise, a Schedule I substance under the Federal Controlled Substances Act. I recently dealt with an issue with the NRMP on that. Program was seeking a waiver on that basis, and my client was obviously in the right, but it's still it was one thing that really could have been anticipated a little bit better. Another one that's come up recently is if you have a religious or disability related exemption to the COVID vaccine, you need to be on top of that. You need to make sure you know what the process is for asking for an exemption. Is the program you're applying to even allowing exemptions, or have they invoked what's called the undue burden exception to the exemption? So those are the kinds of things, like if you have some kind of special thing or status about you that might sort of run afoul of a employer's expectations or wants, that's something you want to try and start thinking about ahead of time.
Okay. And this next question is from Tig. This one, all right, here we go. Thanks for answering questions. So recently I asked to resign from my residency program about 3 days before the last day of my last rotation of intern year. Is it legal for them to do that? They put me on a remediation plan, but they did not tell me I failed the remediation program until the same day they asked for me to resign.
So that's sort of a bizarre scenario from my perspective. I mean, just based on those facts alone, you kind of be a little bit curious about what happened before, this remediation plan. Was there some kind of feedback? Because one thing you have to recognize is that while the ACGME says, you should be putting people on remediation plans, they also say that you don't necessarily have to have all feedback in a written format. Verbal feedback is okay. And that's, again, this comes back to that sort of tip about, before the, discipline happens and you're on remediation, be documenting and not just for yourself, not just a journal that you keep, but, something you can send to the attending. And if they don't respond back, you can say, well, if you disagreed, you would have written back and said, I disagree. Here's what I actually said or whatever. So I'm curious about sort of what preceded that. Asking for somebody to resign is ostensibly okay. It's basically the handwriting is on the wall that if you don't resign, this is probably not going to end well for you, and this is kind of the graceful way out. But that doesn't necessarily mean that they'll prevail if it gets to that point. But you should now be on guard that this is the direction it might be heading, and you really need to be mindful of those pre-discipline kinds of tips.
Okay. All right, Tig, thank you for that question. How should residents deal with serious discipline once it is imposed?
Yeah, so the first thing is you need to immediately figure out what your policies, if you haven't already. And my hope is that if you're following along, you've kind of minded my advice and you have already kind of started to think about what happens next. What if they do impose some kind of discipline? But if you haven't done that yet, go right to your house staff manual, resident handbook, GME policy website, wherever it is, and either find the words due process or grievance or some appeal, something like that is then going to lay out for you what you have to do and when. Because I'll tell you one thing, one of the biggest rude awakenings for me when I started doing this 14 years ago is the exceptionally short period of time that programs give residents and fellows to activate that appeal process. At some institutions, it can be as little as 48 hours. And sometimes it can be as much as 30 days. So you can see it runs the gamut. But on average, I find that it's about 5 days. So then what do you have to do in that 5 days? Is it what we call sort of a notice-based policy where you just have to let them know, look, I want to appeal this, and that's sort of, get your foot in the door, and then you can sort of give them your arguments later? Or is it one of the ones that's notice plus, which is, I have to tell you I want an appeal, and I have to tell you why. I have to give you some description of varying levels of specificity of why I disagree with the action that's being taken against me. So you've got a very short period of time usually to activate that and to tell them what you want to tell them. My advice is always to leave yourself a little bit of breathing room and say, and I sort of reserve the right to supplement this, with additional information so that if you get counsel later on or something else occurs to you, you're not sort of locked in. But usually my experience is that, there's not what we call sort of a waiver. In the legal world, if you don't make an argument at some point, you've waived it. If you wait too long, usually that's not something that happens in these kind of internal appeals, but you want to be, getting your arguments in a timely way. And if you miss that deadline for requesting an appeal, most policies will say that it's deemed final, you've not contested it, game over, and that's it. And so, again, locate competent counsel to help you out with the appeal process. I hear all the time, whether it's from, GME directors or the clients themselves saying, I'm basically being told that the fix is in, there's no point to this, I'm never going to win, the program's always going to win. I wouldn't be doing what I'm doing if we weren't successful. Now, we're not successful all the time. Every case is different, but you don't want to lose that valuable right. I mean, it's not a right that anybody else really has in the employment world. It's there because the ACGME says they must offer it, and so they do. and you want to try and make the best use of that. Be wary about signing any kind of disciplinary letters where your signature means anything other than I'm acknowledging receipt. Don't sign anything where there's any ambiguity as to you agreeing with it or conceding that point. And if you're not sure, you can always just sort of add a line over your signature that says, I'm signing this acknowledging receipt only. Because you really don't want to be seen as sort of obstructionist and refusing to sign something that's just acknowledging receipt. That's usually kind of taken the wrong way. And be cautious about offers to resign without understanding what your appeal rights are, what your legal claims might be. And another big one is, what's going to happen after you resign? What are they going to say about you? What is your summative evaluation going to look like? Are you going to have a letter of recommendation? What kind of answers are they going to give on the verification forms? I mean, there's a lot of things that you really want to try and figure out before you say, yes, I will resign. Because once you basically give that resignation promise, then it's over. There's really no more bargaining at that point.
Okay. Next question. Can a resident be sued during residency? That's a fun one.
Yeah, so the answer to that is with most legal questions, it depends. But generally the answer is yes for the most part, and that's going to vary based on jurisdiction. So I can't speak to all the 50 states and the territories, but what I can say is that for those of you who are interested in this particular the evolution of this legal issue, a good place to start is looking at the Libby Zion case from New York in the 1980s. I'll spare you all the details, but it was essentially two residents who were working 36 plus hour shifts. This was before duty hour rules, and this actually prompted a lot of them. They were carrying dozens of patients with only offsite supervision, and it's probably not surprising to hear there was a bad outcome on one of the patients who spiraled downward clinically and then died. The case, as I said, sort of prompted duty hour restrictions, now called work hours, and reforms to supervision requirements. But basically, one of the things that's sort of interesting about all this outgrowth of those reforms is the ACGME says in its own common program requirements that the attending is the physician who's ultimately responsible. But that's not what is legally binding, on plaintiffs who want to sue their providers. So if somebody was participating in the care and they think that person's care was below the standard of care, was negligent in some way, that provider can be sued. And so then the question becomes, what's the appropriate standard of care for a resident or a fellow? They're not, sort of completely fully licensed. They're usually on some kind of training license or something like that, a temporary license, and obviously they haven't been board certified. And so in some jurisdictions, what you see is where that resident or fellow can be sued is that there's a somewhat less imposing standard of care for that provider because you're not expecting as much from them as an attending with 20 years experience and board certification and fellow of this and that. So that's kind of one of the issues that you see where suits are possible against trainees. And what's interesting is that a 2019 study in the American Journal of Surgery, they reviewed over 57,000 cases filed between 2007 and 2016. Of those cases, 4% identified a resident physician as the defendant. So you can see it's not very common. This is surgery. But 750 cases were 32% of that 4% were surgery specialties. So you can see that that's a specialty where residents and fellows are in the crosshairs a little bit more. But yeah, I mean, there's definitely some more sort of education you can do for yourself on that. The AMA has the GME competency education program on its website, and there's a little module called Anatomy of a Lawsuit, and that's something that certainly folks could look at for a little bit more information.
Okay, excellent. Again, any questions you guys have, please submit them in the chat. So what rights do residents have with respect to paternity and maternity leave?
Yeah, I mean, that's definitely an interesting one, mostly because your status as a resident is an interesting one. It's a hybrid of a student and an employee. And so most jurisdictions will at least look at, the employment side, if not also the education side in terms of your rights. And there's all kinds of federal laws and regulations. There's also state ones with respect to parental leave. The federal law is the FMLA, and basically it's the Medical and Leave Act that says if you are an eligible employee, so you've worked the minimum period of time to have those rights, then you can take a certain period of time away from your duties and to, whether it's take care of yourself, take care of your child. This includes both adopted children, foster children as well, and take care of those responsibilities without worrying about your position, disappearing. But states, there are various states, and I think California and New York might be two examples where there's actually more protection. And one example of where states can offer more protection is under the FMLA, that leave is not paid, whereas under some state laws you can actually have that period of time be paid. And so that's certainly a nice benefit. Residency doesn't pay well as it is, and so every little bit you can get is definitely helpful. But yeah, if you're experiencing any issues with parental leave, another resource is some of the specialty boards have started to issue policies about leave time. And so even if you don't want to take it to sort of escalate it to the legal realm, one thing that you might want to look at is, does your specialty board, so if you're internal medicine, the ABIM, do they have a policy? Yes, they do. American Board of Pediatrics does as well. And a lot of those have actually changed in recent years to be a little bit more understanding of residents who are also parents. And so you might want to sort of point out to your program, hey, the board says, I can have this time away, and it doesn't necessarily extend my training. The ACGME has done that as well. So there are protections, and not just the legal ones, but you might be able to kind of, cite to those more graduate medical education specific resources and get them to do the right thing.
Okay, interesting. Next question. And again, guys, any questions you have for Greg, please submit them in the comments. Here we go. What should residents know about employment laws, and how do they apply to residents within their hospitals?
Yeah, so I mean, this is again sort of the interesting issue of being a hybrid person. You can basically assume for most jurisdictions that you're going to be treated at least as an employee, and some of that's going to be a little bit determined by what some of the state cases have said about somebody with your status. It also going to be controlled by some things like what your contract says. Does it refer to you as a student, or does it treat you as an employee? Does it, sort of set all the indicia of whether somebody's employee is, can they control where you go, when you go there, how you do it, how you get paid for it, how they pay you for it, things like that. But most of those in the residency world line up with employment, and so all of the normal protections that you would have against anti-discrimination, laws. So we talked about a couple of those in terms of, the interview questions. All those same rules apply. They can't terminate you because of your race, religion, disability, and so forth. There are obviously some things that also parlay with the parental rights. You really want to make sure that you're aware of what kinds of things cross the line, and if it feels like it's sort of disparate treatment. Let's say, for example, you are being disciplined for not doing X well. Well, you also have a co-resident who's not doing X well, but they're in a different class than you. For example, you're black and they're white, and you're saying, well, why aren't we being treated the same? That's a classic example of what we call disparate treatment in the employment law space. And so there might be some explanations for that. Some things maybe you're not aware of that contribute to that. But if you start sort of getting inklings about, someone who's otherwise in the same shoes as you, but is being treated more favorably than you are, and you're in one of those protected classes, that's when you really start to need to get some advice about what you can do there. And one major issue that I see a lot in my practice is residents with disabilities and how they go about asking for accommodations. And unfortunately, in the medical world, it's sort of counterintuitive, but there's this concept in disability rights movement known as the medical model of disability, which is essentially mostly physicians or medically minded or similar professionals sort of thinking of people with disabilities as being a broken person with something wrong with them and not able to do certain things because of that. And that's a very paternalistic view at the very least, if not sort of explicitly discriminatory and bigoted. But it does happen, and so there's a lot you can do to sort of combat that attitude, and making sure that you're advocating for yourself and asking for accommodations, as long as it's something that is not going to cost them undue sums of money or is going to change the fundamental aspects of your job. You can get an accommodation so that you become on the same level playing field as your peers. It lets your abilities dictate your performance as opposed to the things where you have impairments. So that's one big thing I see in my practice that I guess I just wanted to comment on. But yeah, I mean, the same kinds of things that apply to all employees apply to residents. It's a slightly different analysis because of the work you all do. And oftentimes patient care is a big thing that gets bandied about by the programs. Well, if we did this, then it would impair patient care or would compromise patient safety. And you really do have to be careful about pushing back on those kind of generalized statements. I mean, they really have to have a specific reason for example, refusing to accommodate somebody where it otherwise would be reasonable.
Okay, cool. So wasn't sure we'd have time for this one, but let's jump to it. What do residents need to know in the event they encounter licensing disciplinary issues?
Yeah, I mean, it can happen. Sometimes some of the things that can get you in hot water with your program might be things that end up being licensing issues as well. You have to realize that a lot of times, if there's disciplinary action taken at the program level, unless you have credentials and privileges at your institution, which is rare for residents, that information and actions that they're going to take generally aren't reportable to a licensing board and not to the the National Data Bank and the National Practitioner Data Bank. But you do have to sort of be aware that if there's a dismissal, and that's obviously a change in your status that was not anticipated, not normal, those are the kinds of things that might be reported to a licensing board. Licensing boards have their own set of procedures, usually a little bit more rigorous, a little bit more what we like to think of as lawyers' due process built into them. So I can tell you, Maryland, and every state's a little bit different, but if you as a practitioner, what you will get is a notice from the licensing board saying, we've gotten a report that, you violated the Practice Act in this way or that way. You have 10 days to give us your position on why you think that that's not the case. And again, this is something where having somebody who has got experience in dealing with those things is really important. And we usually do, when we find something, we jump on Google and we find it. That's how a lot of clients find me. And you can look up licensing defense lawyers in your state and find somebody who's got an awful lot of experience dealing with that board. Usually they know the investigators, they know the executive director of the board, they know how to ask for extensions, they know what the standards of proof are. As I said, there's usually a little bit more procedural protection, usually a little bit more time than what you get inside your program. But those are high stakes, because obviously if you get a licensing action that's going to imperil your license in that state, a lot of states have a reciprocity agreement where if they impose discipline, usually all the other states in that reciprocity agreement are going to do likewise. And so that can sort of be a domino effect. And anytime you then go to apply for licensing or even credentials, later on in your career, you're going to have to be answering about that. That's always going to come up. So again, sort of getting out in front of it and dealing with it the right way the first time is super important.
Okay, excellent. And we have a couple of more pre-prepared questions. Any questions you guys have for Greg, please submit them in the comments. what is the role of the ACGME and how are complaints to the ACGME handled?
Yeah, so the ACGME, like the NRMP, has its domain, and they are, jealously guard their authority in that respect. So the ACGME obviously sets all of the accreditation standards for programs, and a lot of those are important for residents and fellows directly. Some of them sort of influence your lives indirectly, but things like knowing what the obligation is for programs to provide call rooms, and if you're a nursing mother, a milking location, a nursing location, that's not a bathroom, or things like that. Your duty hour. I mean, a lot of these things influence your life on a day-to-day basis, and it's good to be familiar with them. The biggest misnomer I think I encounter in my practice is you have folks who say, well, my program's violating this specific program requirement. So now I've got my program dead to rights, and I can go to the ACGME and try and get my termination squelched because they're not following the rules. And the sad realization is the ACGME does not intervene. They don't get involved in the disciplinary process. They're very explicit about that on their website, and if you call them and try and talk to them about it, they'll say, look, we're more than happy to investigate and take any appropriate accreditation actions, put the program on probation, do a site visit, do a special review, whatever the case might be, maybe even take the program off accreditation, but they're not going to come in and be a referee in your particular dispute. And so the complaint process can be leveraged, and sometimes programs are a little bit more concerned about it than others. Just be aware that it's not a panacea. Complaining to the ACGME is not going to solve your problem directly, and a lot of times, folks just sort of expect it to sort of be a silver bullet, and unfortunately, it's not. But the ACGME does have an ombudsperson's office, and so there are some things where you can count on the ACGME for a little bit of help if you're having problems. Let's say, for example, a common issue, you need verification of your training, and your program is just dragging its feet on that. Well, the program requirements say that they've got to provide it within 30 days of the request. Well, let's say it's now day 35, and you're still waiting, and you're not getting any help, and they're not responding to you. You can go to the ACGME ombudsperson and say, they owe me this. It's been past the deadline. Can you help? And oftentimes what they will do is they'll reach out to the DIO at your institution, and they'll say, we've got, Dr. So-and-so here. They're not getting their verification. Can you, sort of get this done? And oftentimes that's where they can potentially be of help, but they're not really going to intervene in the more meaty, sort of disciplinary issues, unfortunately.
Okay. So, Greg, we got about 12 minutes left. We got some questions from the comments. We're going to have to go a little bit rapid fire. This is a three-parter, so we'll just get after it. One, what is the timeline for taking legal action against the residency program? And the second part to this question, what should you keep in mind if you are in a toxic, malignant program where residents are constantly dismissed or terminated? And what if your program lies on your evaluation, for example, stating they are supportive, quote unquote?
Right. So I think the first question was, what are your timeframes for legal action? And that's really going to depend on what your claim is. So let's take a common one. So let's say it's discrimination of some kind. So at the federal level, at least, you have got a very short period of time to do what's called administrative exhaustion. So let's say it's a law that's enforced by the U.S. Equal Employment Opportunity Commission. So it's race, gender, disability, whatever kind of discrimination. So you have to make a charge of discrimination complaint to the EEOC or its state equivalent. So in Maryland, it's the Maryland Commission on Civil Rights. And you need to tell them, you need to check the boxes, literally their boxes on the form for, I think it was because of race, or I think it was because of disability. And then there's a box you can fill in with the narrative of why you think that's the case. You got to do that in Maryland and other states where there's a state law that also prohibits the same thing that the federal law does. So let's say disability discrimination. So you've got 300 days from when you experience the discrimination to make that complaint. If you do not, you have waived that claim. And then once you get the EEOC through its process, then you have to, once they issue a right to sue letter, then you've got 90 days to take that case to court, or else again, you lose that claim. Breach of contract issues are another common thing in residency, and that's going to vary by state. In Maryland, it's 3 years. It's other places it's going to maybe be more or less. So you really do have to check with local counsel on that. Second part of that.
Document everything.
Yeah, I mean, if you've got a real malignant program and people are going down like flies, you can obviously try and stick it out and see if you can't make it through and sort of be one of the lucky ones. The other thing is try and get the heck out of Dodge, right? I mean, you can try to transfer out and see if you can land in another program. Even if it's sort of, you got to get creative with the reasons why, so that they don't sort of take umbrage at the fact that you're trying to transfer and they try to scuttle your chances. That's maybe one thing that you can always do is try and transfer out. The other thing is, just again, be very on top of things. Follow all the tips around. If you sort of feel like things are going downhill and you're on remediation, you really got to keep up with your documentation and being mindful about what's happening and try to respond as much as you can, so you create your own record that you can use later on down the road if need be. And the third part of that was, so your program wise. Yeah, I mean, that's a tricky one. A lot of times what happens is you get to these internal appeals processes, and the committee or panel that gets assembled to review everything is essentially going to take as gospel what's in those written evaluations. Some institutions and programs have policies where you can actually provide your own, it says specifically in the policy, you can provide your own response to an evaluation, and that gets put into your file. And so if you have that opportunity, again, this is where knowing what the policies say is super important. Know what your rights are and opportunities are. Even if you don't have a policy that says you have that express right, this may be your opportunity to write an email to either your program director or that attending and say, I appreciate the feedback, and try and be as polite and professional as possible in pointing out, where maybe support was not there, or support that you've asked for that's not been provided, or things that you are now sort of aware of that would be helpful to you that you would like for future rotations. Whatever the case might be, you gotta start building your own record, because that's what the programs are doing. They're building a record, and you need to do the same.
Okay, so we got a couple of questions left. This one's from Yvonne. I've seen some applicants not know whether to report expunged legal records. Sometimes it's okay for the residency, but not for licensure later. Should an applicant disclose absolutely everything?
Yeah, so that's a tricky one. I mean, some of it, again, is dictated by state law and what's okay and what's not. And you do have to be mindful of what kinds of questions are going to be asked in different circumstances. Employment might be a little bit different than credentialing. And again, the state laws are going to vary on at what stage things can be asked. So a lot of times the most basic protections on criminal history are going to say, you can ask about it, but you can't do it in the application process. You have to wait to an interview. Others say, well, yeah, you can't do it in an interview. You have to do it once there's a conditional job offer. So you kind of got to be aware of the state laws on that. A lot of times there is a winning strategy to being open and forthright with whoever it is you're dealing with. Especially if you don't really have anything to hide, you can sort of put a good spin on it. You can say, it was a learning experience. I've benefited from it. This is sort of why I'm a better applicant because of it, as opposed to trying to hide it. Because I can tell you from experience, one of the things that licensing boards hate the most is being lied to and having things hidden from them. A lot of times, if you just said at the outset, this is what happened, and yes, I was dismissed for, professionalism or whatever, as opposed to sort of trying to find some kind of loophole that's, I was entitled not to say it because of a confidentiality agreement or something like that. Well, maybe that's true, But a lot of times they really do look askance at, applicants, trying to hide things from them, and they then their antenna are up, and they're sort of scrutinizing everything. And so obviously everything's a case by case situation, and that, I can't give anybody, in the webinar, legal advice, but generally speaking, what I find is, just coming clean and putting a good spin on it is the better approach.
Okay, awesome. Thank you for that question. And last one here, should physicians who are becoming attendings have a lawyer review their first attending contract?
Absolutely. This is one of the not a baby answer questions. I mean, attending contracts, and, obviously it depends on the level of complexity changes based on whether it's an academic setting or whether it's, a truly private practice, what kind of specialty it is. Things can get very complex very quickly. And, things like, RVUs, do you know enough about what the market will bear and what the going rate is for RVUs in your specialty and in your jurisdiction and your location? So you don't want to shortchange yourself, particularly if the contract is for, a good number of years. Now, a lot of sort of initial contracts might be shorter, but you don't want to lock yourself into a bad deal just because you didn't do your homework. And there are lawyers out there who do enough practice with experienced physicians to know, without having to, sort of guess what the market will bear, and understand all the other terms that are going to be important for your contract. Whether it's, what kinds of professional liability or malpractice insurance is going to be provided. Who's providing that? What kind of coverage? Is it as claims made? Is it something that's going to be to your benefit, or is it going to be, sort of the more universal kind of coverage, regardless of whether the claim was made during the coverage period? So, those are super important details that, really, I think you may be a very accomplished physician, but leave the legal work up to the lawyers. Just like, I don't try and diagnose myself when I have a malady. I go see a professional. And so my advice is, wherever you are, look, and it doesn't have to be me or my partners. Do get that advice, because you don't want to find out the hard way that you should have just had somebody look at it. And a lot of times you'd be surprised how amenable employers are to negotiating some of these things, particularly if it's something that's super important to you, like schedule and coverage and administrative time, or whatever the issue might be. They'll make allowances, particularly if they're interested enough in you. If you've got a good background, you can sort of throw that weight around a little bit and get the things that's really important to you.
All right, excellent. So that's all the time we had, guys. If you want to learn more about Greg, his firm, and what he does, you can find the link to his profile at his firm in the YouTube description. Greg, thank you very much for your time. Thank you to everybody for your questions. Really appreciate this information.
Thank you, everybody.
All right, everybody have a great rest of your day.